The next case to come before the court is Rob Schultz v. Fairlawn Office Park 1 LLC et al. Each side will have 15 minutes to present your arguments. I know that we have two appellees here, so I know that I just want to remind you that you will have to split your time accordingly. So hopefully you've made arrangements to do that. The appellant here may reserve up to 5 minutes for rebuttal. If you do plan to reserve time, please let me know, as I'll be keeping track of the time. The arguments are being live streamed on YouTube and will also are being recorded. Please keep your voices up. You should not use the names of any children or minors or victims, should that be a part of your argument. You can use initials or generic terms. The judges have read your briefs and we're ready to proceed when you are. And I would ask counsel for the appellant whether you'd like to reserve any time for rebuttal.
Yes, Your Honor, I'd like to reserve 5 minutes.
Okay, and one last thing, please introduce yourselves before you begin. And you may start when you are ready.
May it please the court, I'm Natalie Neese for the appellant Rob Schultz. Your Honors, Mr. Schultz fell while leaving his place of employment in a parking lot that was, by all accounts in this case, a sheet of black ice. A parking lot that the defendant, PSF management, admitted was in an extremely dangerous and serious condition at the time. Both defendants in this case testified that they, as the landlord and property management company, were the people responsible for the snow and ice removal at that premises and location. That was a duty, now maybe normally they wouldn't have had under common law, but they had agreed to assume via a written lease agreement.
Counsel, let me stop you. One of the questions I was wondering, and I haven't had an opportunity to review the complaint yet, but in your complaint that you filed against the defendants, did Mr. Schultz actually allege that there was a contract and they were under a duty to clean the property or keep the property clean of snow and ice?
Your Honor, yes, in fact, we did. That was part of our complaint in this case.
Thank you.
Okay. And Your Honors, the defendants breached that duty under that expressed agreement when they did absolutely nothing to treat or remove the ice at the premises before Mr. Schultz fell. While defendants...
Sorry, counsel, does the record tell us when the parking lot became icy? Was it before he got to work? Was it during the time he was there? What does the record
Sure. So the record isn't clear of exactly the moment that the premises became icy. What we do know from the testimony is that that there had been multiple complaints during that morning about ice on that parking lot, that the employer and its employees were very upset about the condition. We also know that there was no rain event, snow event, anything that happened that morning that would have put the ice there. So I think that it was fair to assume that that ice had been there early in the early morning hours based on the testimony that we have. But do we know?
Is it fair to assume that it's a question of fact then when the ice accumulated?
Correct, Your Honor.
Are there any time frame when the complaints came into the PSF or the management company? Was it before the fall or after, or is that clear in the record?
I think that that is clear in the record that the complaints came in before Mr. Schultz fell. Okay, the exact timing, you know, was it this one at 7, this one at 8? We don't have a record of, but we do have testimony that there were multiple complaints that came before Mr. Schultz, in fact, fell at the parking lot.
If I understand the trial court's factual findings, the trial court seemed to have found that the ice accumulated sometime after he got there, but before he fell. Do you question that factual finding by the court?
I do question that factual finding for the reason we just said. I think that's a question for the jury. I don't think that that evidence is there. What I think the trial court did was relied on Mr. Schultz's testimony that when he got there, it was dark, it wasn't well lit. He was the first car there and he walked in without incident. I don't think that that led to the conclusion that there wasn't ice. I just think that that led to the conclusion that Mr. Schultz didn't fall. But I don't think there was a basis for the trial court to reach that conclusion. Now, Your Honors, I think the other conclusion that the trial court reached was that there was no evidence that defendants breached their duty to Mr. Schultz when they did absolutely nothing to treat the parking lot. And I think the evidence was completely contradictory to that. And certainly there was enough evidence for this case to go to a jury. While the defendants ultimately, the trial court claimed that defendants just, hey, they met their duty because they hired a snowplow company in this case and had made a statement in a reply brief, a one-liner to that effect. Your Honor, that contract was never put into evidence by the defendants, and it is not part of the record, nor was that contract alluded to in defendant's original summary judgment motion. Because it wasn't part of the record, the court didn't have an opportunity to review it and certainly could not know what was in it and had no way to determine that the facts in that contract or the terms of that contract applied to the allegations in this case, which they did not. You know, the court's relying on that conclusory one-line statement in a reply brief that there's a snowplow contract does not meet the evidentiary requirements for a dispositive motion under Rule 56. And notably, that snowplow contract in this case didn't address the duty that the defendants had assumed in this case. That contract, as testified to by defendants, required a snowplow company to come out in situations where there are 2 inches of snow or more on the ground, what I call a snow event, right? Admittedly, the contract failed to address the situation of what happens when it's an ice-only event. There's no snow on the ground, as was the case here. When there's an ice-only event and there's no snow on the ground, the snowplow company is not obligated to come out pursuant to the contract unless the defendants affirmatively call them and request for them to do that. When PSS, through their representative, Mr. Lully, was asked what process is expected that you will follow for removal of snow and ice in an ice-only event, he testified he expected his personnel to arrive at the business and inspect that parking lot before other employees arrived. He also testified that he had no evidence to support that that inspection had occurred. He said that at the time they notice a problem in that inspection or otherwise, it is incumbent on their representative to immediately call the snowplow company and have them come out and engage in some de-icing and ice removal activities. That did not happen. He said he expected the parking lot to be treated and de-iced before employees arrived for work. There was no treatment done of this parking lot. PSF acknowledged that there had been multiple complaints before Mr. Schultz fell and that the maintenance person should have called immediately at the time of the first complaint, called the snowplow company. That didn't happen. In fact, the testimony is in this case that the maintenance person didn't know the snowplow company's number and called the boss to ask him, what should I do? I'm getting all these complaints. There was no salting or de-icing that occurred prior to Mr. Schultz's fall. The snowplow company in this case arrived while he was being put in an ambulance. There were no warnings given to Mr. Schultz about this grave situation, and defendant Mr. Lully testified he felt that was necessary given the gravity of what was going on. After Mr. Schultz fell, the testimony was that his employer demanded the maintenance person on site not be able to return to that location out of frustrations for their delay, lack of responsiveness, and unwillingness to take the situation seriously. Your Honors, there was ample evidence in this case for reasonable minds to conclude that defendants breached their duty and responsibilities for snow and ice removal, and certainly enough to create a material issue of fact for a jury. This is evidence that the trial court completely overlooked, and I'm asking for reversal on that basis.
On the question before you rest here on as to superior knowledge, the trial court found that the defendant did not have superior knowledge regarding the ice and snow in this case. Do you think that goes to the duty standard or the breach of duty standard? Where did that fit in our analysis of negligence?
I think that goes to the duty standard. I think that courts have used that as an exception to that general no winter duty rule that the defendants cite to. So in common law, you know, generally landlords and the property management companies don't have a duty to tenants to remove snow and ice. And the court said we call that the no duty winter rule, right? You live in Ohio, you know it's going to snow. We're not going to put that duty on. There are exceptions. One exception is if you've contracted to do it. So you said, hey, forget that, I'm going to agree to do so. But the other exception is if it's situations where for some reason the landlord has superior knowledge to that of the plaintiff as to which they have more notice, right? And then the court would put that duty on them in that situation. I think that under the facts of this case, that exception would apply given how much information the defendants had versus Mr. Schultz. But regardless, it's really not applicable because we have this exception and that creates a duty under the contract. Your Honor, the other issue I take real issue with in this case is the court's determination that the plaintiffs failed to present.
Counsel, I do want to
Yes.
let you know that you're moving into your rebuttal time.
Okay, Your Honor, I'm going to wait and pass to the defendants and hold on to that.
Very well. The appellees may proceed.
Good morning, Your Honors. May it please the court. My name is Kyle Kramer, and I represent the appellee Fairlawn Office Park 1 in this case. Your Honors, as has been discussed, this is a slip and fall case on a natural accumulation of snow and ice. And this case boils down to the application of the legal doctrine known as the no duty winter rule and whether any applicable exceptions to that rule apply to the facts of this case. As set forth in detail in my brief, our position is that the legal doctrine does apply and none of the three exceptions to the rule are applicable under these facts, Your Honors. The no duty winter rule is a long-standing legal doctrine that simply asserts, as counsel for the appellant indicated, that in Ohio, when it's concerning a natural accumulation of snow and ice, an owner or occupier of the premises generally does not owe a duty to remove the snow and ice or to warn business invitees of the condition of the property. This is a more expansive doctrine than the open and obvious doctrine, as it doesn't have to do with what an individual is capable of observing, but rather what a reasonable individual should expect or anticipate regarding a situation. There's three exceptions to this rule. The first is when the owner or occupier of a property is actively negligent in permitting or creating an unnatural accumulation of snow and ice, i.e. a man-made accumulation of snow and ice. There are no facts or evidence in the record or even allegations that such is the case, and so I won't discuss that exception any further. The other two, however, appellant has both claimed are applicable in the context of this case. Second exception being the superior knowledge exception. Now, this exception only applies when the owner or occupier of the property has superior actual or implied knowledge that the condition of the property is more dangerous than the invitee should reasonably assume. Now, this court, in their holding in the Goodwill versus Sutcliffe case, as well as the third district in the Bakes v. RSM case, both of which are cited in my brief, set forth the fact that this exception is specifically limited to situations of hidden defects and hidden dangers in the property. For example, if there was a hole, a spike, a ledge, something that a property owner would be aware of as a dangerous condition, such condition is concealed by the natural accumulation of snow and ice, then in that context, the property owner or occupier would be held to a standard of having superior knowledge to the invitee, thereby creating a duty. Those simply aren't the facts in this case. Regardless, even if such exception was not narrowly construed to hidden defects, there's no evidence in the record whatsoever that my client had any knowledge of the condition of the property on the morning in question of Mr. Schultz's fall. Fairlawn Office Park 1 does not have any employees or representatives physically located at the property in question. They're an out of possession owner of the property. There's no evidence, there's no testimony, there's no facts in the record that show prior to Mr. Schultz's fall, there was a phone call, an email, a text message, a complaint, etc. Nothing to any representatives of Fairlawn Office Park 1 to notify them of the condition of the parking lot.
Well, to your position that PSF is not the representative of Fairlawn for the management or the maintenance, excuse me, of this property.
As it relates to occupying the premises, correct, Your Honor.
So how would they get notice of something wrong with this property from an employee other than it going to PSF first?
Well, it would go to PSF and then PSF would have to relay that on to Fairlawn, Your Honor. And in this case, there is evidence that that happened after the fact, but there's no evidence in the record that anyone from Fairlawn was ever placed on notice of the condition of the property prior to Mr. Schultz falling.
So PSF may have been told before the fall that there was some issues with the ice on the property, but your client was never told of that. Is that correct?
That is correct, that my client was never told, and there may be a question regarding the first part of your question, Your Honor.
A question of fact regarding that?
There may be.
Okay.
Regardless, I don't believe that if there was a question of fact concerning that detail, it would be a genuine question that would allow this case to move forward past summary judgment. I will now move on to the third exception, the express contract exception, which appellant has discussed in detail. The exception here is predicated on the fact that if there is a written contract where a landlord assumes a duty, that can be an exception to the no duty winter rule. This exception requires expert evidence to be established. The facts of this case are almost identical to the facts of the Bakey's v. RSM case, and also this court's holding in the Brockman v. Terminal Warehouse case, which was cited in the trial court's order. If there's no expert testimony, then the plaintiff is not able to establish, one, the scope of any duty created by contract, and two, whether there was a breach of that duty. And so without expert testimony, at best, as the trial court indicated was assumed, you may have a duty of ordinary care, which in this case, there's absolutely no evidence that that duty was breached. I would assert that even if nothing was done with respect to the property, it would not be a breach of any ordinary duty of care under the common law doctrines that are applicable in this case, as I've already set forth. However, that's not the facts of this case. There was a contract with a management company and a snow removal company to handle the property, and assuming that there was a duty of ordinary care placed upon my client in this case, there are no facts that that was ever
lost Judge Carr for the moment, as far as I can tell. Judge Sutton, would you like to continue to proceed until she gets back? I have not done before on Zoom. I don't know what our policy is. If we lose it, oh, there she's coming back. Good.
Shall I resume your?
I'm sorry, I somehow got lost here in the shuffle.
It's okay. We're all back together. Mr. Kramer, you can proceed when you're ready.
Thank you, Your Honor.
Let me ask you, Mr. Kramer, in this case, it seems to me that the duty that you have would be the duty listed under the contract and not that of ordinary care, which would be to keep it reasonably free from ice and snow. Wouldn't that be your client's duty?
Well, sir, the duty from that language in the lease necessitates expert testimony to set forth the scope of that.
I can understand in the case where we said you have to have a duty to keep it to the highest industry standard, the language of that effect that would be somewhat technical. How is reasonably free from ice and snow something that only an expert can tell me what that means, or a jury member? Why can't a jury member know what reasonably free of ice and snow means and make that determination if your client's met that standard?
Well, Your Honor, I believe the case law from this court in the Brockman v. Terminal Warehouse case, as well as the Rampersad v. Madison case and the Bakey's case that I've cited in my brief, I believe that those cases are all harmonious in that when you're dealing with a commercial property and you're discussing the standard of care on plowing or maintaining that property, expert evidence is required.
Did they talk about that was needed for breach or defining the duty that was listed?
The court specifically indicated in the Bakey's case and the Brockman case that expert testimony is needed to establish the scope of the duty and breach. So I would assert that both of those elements necessitate expert testimony.
Counsel, I was going to, whenever I was somehow lost connection with you, I did not hear the answer to your question. Do you agree that the complaint did in fact mention an alleged duty via contract?
The complaint does include a claim for breach of contract. Yes, Your Honor.
So wouldn't it be your duty then, as the movement for summary judgment, to then in fact talk about expert testimony and so forth and what that duty entailed in regard to the contractual duty in the summary judgment motion you made?
I'm not sure the answer to that question, Your Honor. I think due to the progression of the case and the fact that there had been no expert testimony ever included in the record, that I did not assume that argument was going to be made by counsel. As such,
Counsel, let me interrupt you if you don't care. I want to make sure I'm understanding this correctly. If a contract alleges an allegation, isn't it the duty of the moving party to dispute that allegation and prove there's no genuine issue of material fact in regard to it?
If I understand your question, Your Honor, I believe so.
And so your mention of an expert and the contractual duty didn't actually take place until the reply brief.
That is correct, Your Honor.
Okay, thank you.
In closing, to reserve some time for the co-appellee here, the second assignment of error asserted by Mr. Schultz concerns whether or not the trial court erred in the motion to strike. This does go to your question, Your Honor, recently asked, and I do not believe that the trial court did anything arbitrary or unreasonable, as they properly indicated. There was a legal doctrine asserted in the motion for summary judgment. In plaintiff's opposition, it addressed certain exceptions to that doctrine, and the reply brief was a direct response to those alleged exceptions. As such, I would request that this court affirm the trial court's order granting the motion for summary judgment as to Fairlawn Office Park 1. Thank you.
Thank you, Attorney Kramer. You will have a little over 6 minutes for your time, Mr. Traub.
Thank you very much. May it please the court, excuse me, counsel. My name is, Randy Traub on behalf of PSF Management in this case. I'd like to backtrack just for a second to answer Judge Stevenson's question with regard to the necessity of expert witnesses. First of all, as to the argument set forth by counsel for appellant, the contract is part of this record. It was actually attached as an exhibit to the opposition to the motions for summary judgment. The contract language is very clear. It says that my client is required to keep it reasonably clear and free from snow, ice, rubbish, and debris, consistent with a first-class office building in Northeast Ohio. I would submit that that language in and of itself requires expert testimony. To go back to what Judge Carr was just bringing up a second ago, as far as arguments that were raised in the reply in support of motion for summary judgment, the original motion for summary judgment asked for the court to dispose of it pursuant to Rule 56 based upon there being no duty at all, period. It wasn't until the appellant in their reply said, well, we do have a duty and the duty is based upon this contract. It was at that point that my client, responded with the argument consistent with the Backey's holding and consistent with the prior cases here in the ninth.
Counsel,
yes, ma'am.
Let me ask you though the
Yes.
same question I asked the other counsel, and that is, if they raised it in their complaint that there is a specific express contract that created a duty, why didn't you have the obligation and the burden to demonstrate why that duty was not applicable or why that contract did not apply in these circumstances in your motion for summary judgment? That's where I'm trying to figure out why you didn't have to do it at that point.
Sure, and I appreciate that question, Judge. The motion for summary judgment was very, very broad. And it was basically stating there was no duty under any circumstance, whether it be by contract or whether it be by common law. We still stand by that position because the contract itself, there was no evidence that even created a duty, much less a breach of that duty. So the original motion for summary judgment addressed it broadly, that there was no duty owed to the plaintiff or the appellant in this case under these particular facts.
Did the original motion for summary judgment include an argument about a contract?
No, ma'am, it did not.
Thank you.
The courts, though, have been very, very clear, and I agree with counsel for appellant that there typically is no duty, and I don't want to reiterate the same things that have been said over and over here today, that there's generally no duty on a natural accumulation of snow and ice. When you have a situation like this where there's a contract which may impose that duty, it does require expert testimony to explain what the scope of that duty would be. And here, there just was none. I'd also like to address the issue of superior knowledge. Plaintiff testified and the appellant's counsel in their brief went so far as to basically make our argument for us. There was no superior knowledge. This was black ice. In the brief that appellant filed, it said it was invisible to everybody, and that's what black ice is. So there could be no superior knowledge at that time of the fall of the appellant in this case. So without any genuine issues of material fact that would be in dispute as to this particular case, I would ask that this court affirm the trial court's decision granting summary judgment.
Any further questions for counsel?
Thank you, Beth.
Okay, thank you. Counsel for the appellant can continue with her rebuttal. You have 5 minutes.
Thank you, Your Honors. Consistent with, I think, some of the questioning here, the Supreme Court in Mitza versus Wheeler has held that summary judgment cannot hinge on arguments that are raised for the first time in reply briefs, and that the moving party for summary judgment bears the initial burden of specifically delineating the basis for summary judgment in their motion and pointing to evidence in the record that demonstrates an absence issue of genuine fact. In this case, defendant's entire summary judgment arguments hinged on the issue of whether or not they owed a duty to plaintiff. I responded to that and said, yeah, there's this contract. Now, notably, the defendants didn't raise that contract knowing it exists, knowing that exception exists, never brought that in front of the court. That was brief. At that point, knowing there was a contract, knowing there's this a clear exception to common law for a contract, that should have ended the analysis for the trial court in this case. There was a duty. It was owed to Mr. Schultz. Mr. Schultz should have had his case heard by a jury. In terms of responding to this claim that the plaintiff needed to provide expert testimony as to what the standard of care was in this case and to whether the defendants breached that standard of care. First of all, I think I breached it thoroughly. It's very frustrating in a case like this when the motion for summary judgment was filed before the expert disclosure date had even passed. So there are a lot of issues surrounding that. And I think we've briefed entirely how the parties had agreed to extend deadlines. Certainly the defendants took advantage of that agreement when we did depositions beyond the case management order. But when the agreement says that we're going to extend expert deadlines, now they want to come in front of the court and say, whoa, 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 we want the benefit, but we don't want to allow defendants or plaintiffs to have that same thing. The standard of care does not require expert testimony in this case, and none of the cases cited by defendants state that. In fact, the law requires that the standard of care is established by the contract. And numerous courts, include the courts in Hammond that I cite, says generally when you look at a contract like this, ordinary negligence applies. That's what the trial court found as well. The only time expert testimony comes into play is, as Judge Stevens talked about, when we're talking about a contract that specifically indicates a higher duty of care that a reasonable juror may not understand. The defendants rely a lot on the Bakey's case. I'll tell you, that case was very specific to the facts of that case and doesn't stand for this general proposition that you need expert testimony, inconsistent with a lot of case law and the Supreme Court's findings, that in every case that there is an express contract, we have to present some kind of expert as to the standard of care. In Bakey's, that contract specifically said that the defendants in that case were required to follow the highest industry standards for their practice. And the Bakey's court said, look, when we're talking about a contract that has that language, the highest standards ever, then maybe expert testimony will be necessary. That is not the case here. This contract at issue says reasonably clean and clear of snow and ice, right? That is well within the
counsel. Let me just
Sure.
ask you a question in regard to that. I don't remember reading the briefs, and I don't know if this was just hyperbole or whether it was in the contract this morning whenever one of the opposing counsels mentioned reasonably free of snow and ice according to the standards of a office building or whatever. Was that in the contract as well?
Your Honor, that is a misstatement of exactly what this contract says.
Well, what does it say?
Sure, I'd be glad to read it to you, Your Honor. Gotta get my big book. This is what it says. It says, without going into all the first terms, that basically the landlord will keep the real estate reasonably clean and free from snow, ice, rubbish, and debris. And they will adequately illuminate the landscape and drain it, including those items set forth in paragraph 7, which are considered part of the basic operating cost, and otherwise are consistent with with a first-class office building in Northeast Ohio. Nowhere does that say that they have a duty to meet some kind of higher standard. They just say this contract is consistent with first-class office buildings in Northeast Ohio.
Counsel, I'm going to have to ask you to sum up. Your time is up.
Sure, Your Honor, thank you. In summary, what I'd ask this court is, I think that the trial court in this case, the issue before the trial court was whether there was a duty, and in fact, there was a duty. And I think that the trial court just went beyond its purview when it went into issues in a reply brief or not otherwise even briefed by the defendants to rule on summary judgment and claim that, you know, their plaintiffs could prove that there was no breach of the contract. The evidence in this case, there was ample evidence.
Okay, we're going to need you to wrap up. Okay.
We just asked for a reversal, Your Honor.
Thank you so very much, all of you, for your presentations. The court will take the matter under advisement and issue a decision in due course. The clerk of courts will mail a copy of the decision to you on the day that it is released, and the opinions will also be posted on the Ohio Supreme Court website. The court will now be adjourned until